So let's go ahead and get started. I've just got a couple of intro slides, a little bit about LiveWell Jefferson, and then we're going to hand it over to our speakers. So thank you so much for joining. This is our HR update. How will you protect your business from legal liabilities in the post-pandemic workplace? So today we're just going to kind of go over a little bit about LiveWell Jefferson, speaker introductions, and then Fred and Ryan will speak, and then there'll be plenty of time for Q&A at the end. So our focus, LiveWell Jefferson, is focused on creating a culture of wellness among businesses and residents in Jefferson Parish. So we are just focused on the fact that our economy really does depend on the health of our workforce. So we provide resources to help employers basically create a healthier workplace for the health of their business. So if you go to livewelljefferson.org or follow us on Instagram or Facebook at LiveWell Jefferson, we have resources, we have a blog, advocacy, tips, information, events, all that fun stuff. And then, of course, we have to thank our sponsors. So thank you to Blue Cross Blue Shield Louisiana for sponsoring our campaign. They're our presenting sponsor. And we, of course, have our wellness patrons, Biz New Orleans, Entergy Louisiana, Latrim, Oshner, and Tulane Lakeside. And then just a couple of housekeeping items. So our full speaker bios, which are very, very impressive, are on the event webpage. I'm not going to read them fully today, but if you go to the webpage at jeffersonchamber.org, you can see Ryan and Fred's bios. And then we will have Q&A and additional info at the end. So please feel free to submit questions through the chat box throughout the webinar. And then if there are additional links or resources that any of our speakers want to provide to you, I'll make sure to email those out and then also post them at livewelljefferson.org. And then finally, I just sent out an email to everybody with the slides with note pages. So, you know, if you want to take notes during the presentation, feel free to use those as well. So our first speaker today is going to be Fred Preis. He is on our board of directors and he's a senior partner at Breazeale, Sachse and Wilson, L.L.P. in the labor and employment law section. And then our second speaker is Ryan Rodrigue, and he is the managing partner with Hollis Companies specializing in employee benefits. So with that, thank you so much. And we are going to turn this over to Fred. I'm just going to pull this up. Fred, you can just say next slide. I'm going to unmute you.
Ready? Okay, great. Welcome everyone. Thanks so much for registering and being a part of this webinar. And thanks very much to the Jefferson Chamber. I believe this committee, LiveWell, was actually created after I was chairman, and it's a great committee. It was called the Healthcare Committee originally. Alex has done a wonderful job with it, and thanks also to the terrific staff we have at the Jefferson Chamber. Todd Murphy and Alex and all the staff there do a wonderful job. Most of you probably think there are 100 people working for the chamber with all of the emails and bulletins that you receive, but there aren't. There are a handful of people who do a very good job, and I don't know how many people are on. We have a lot of people registered for this who are not members of the Jefferson Chamber, but if you're not, you should be. And I'm sure that if you contact the chamber, email, or call, they'll be happy to register you. So we're going to talk a little bit about what to do to keep yourself out of hot water. Our firm and our labor and employment group work with about half of you, and you know we're very much into preventive maintenance. So we're going to provide a plan to do that. I like simple things. I'm a simple person, and so we tried to break it down, as you will see from the slides, into 5 parts. Too bad you can't see Ryan and Alex and me, because if you could, you would see Alex has got on an evening dress and Ryan and I are in tuxedos. We look wonderful. It's too bad you can't see us. Maybe you'll see us next time, maybe at one of the chamber functions. So I wanted to start a little bit with what I'm going to try to do is pass along to you some of the things that that everyone in every industry is doing. A lot of you are in various and sundry industries. We do work all over the country from California to New York in every industry. So we have had about, I can't count the number of questions, about 600 calls, maybe 1,000 emails and texts in the last 2 months. We're tired and I'm about to lose my voice, but we're hanging in just like all of you are. So I'm going to try to pass along to you some of the events and happenings that others in industries are experiencing, from the banks to the grocers to the manufacturers, the hospitality industry, the restaurants, the hotels, and all of them. We are Labor and Employment Council for almost all those associations throughout a 2 or 3 state area. So I can really tell you what they're doing and what they're experiencing and how you can learn from that. It's been a whirlwind months. Let me talk a little bit about what we have learned. Some of this, most of you already knew, but some of you did not. And some of this was learned from past experiences. So, common threads, eternal truths. Number one, we're dealing with particularly uncharted and unpredictable problems. This is very much like those of you that have went through Katrina or 9/11. It is a lot like that. We were creating resolutions and common solutions to problems that had never been had before, and there was very little guidance. We're still doing that. We got to be innovative and creative with solutions and patch the legal with the practical, and that's what we're trying to do, come up with some alternatives. Second, every day is a new day. The government changes its mind every other day with new guidelines. They post them at midnight. You have to figure out how you can practically do that with a particular industry. And the rules are many times conflicting. So we're not going to talk about specific rules. I'm not going to cite statutes and ordinances and all those sort of things because it'd bore you, bore us. We'd all fall asleep. So we're not going to do that. Tailored. Every industry is different. It's interesting. Typically the industries are different, but this time the issues within the industries are different. So for instance, if you're a bank located in northern Louisiana or in Mississippi, you've got different issues. If you're a hotel located in different places, if you're a casino located in different places, we've done, I can't count the number of webinars, maybe 13 or 14. And for the bankers, all the bankers, all the hotels, all the casinos in Mississippi, Goldman Sachs, and on and on and on. And every single time there's some different issue that people have. And last but not least, learned items are that do it right or you'll get sued. It's just that simple. After Katrina and after 9/11, plaintiffs' attorneys came out with their knives sharpened. The same thing's going to happen here. The unions, the plaintiffs' attorneys, the government officials, those are the three. With wage and hour issues, OSHA issues, discrimination issues. The hospitals, I will tell you right now, we are dealing with a union organizing attempt among the hospitals. We were one of them this past Friday doing supervisor training and figuring out how we're going to resolve situations. So this is going on around the country. The Nurses Association and other unions are trying to make hay out of this unfortunate pandemic. And that's just one piece. So again, we're going to try to do this from a 10,000-foot overview. Ryan and I split it up so we each have about 20 minutes. So after 20 minutes, I'm going to stop. We have, I think Alex has planned another 15 or 20 minutes at the end till midday to answer some questions, which we'll do. I'm really proud to be on with Ryan. He is a real ace. He really is, and he can answer your benefits questions. I think we're going to wait till the end to have questions. So let me start with just a plan to ramp up your business. We said this, we have clients on a continuing basis, so retainer clients, and we gave them this information about 2 or 3 weeks ago. Some of you have pivoted and ramped up already. Some of you have not. I've talked to people all over the country, and everybody's at a different stage. The banks just pivoted about 2 weeks ago. Hospitality is in the process of pivoting, meaning hiring people, trying to ramp up a little bit. The groceries never stopped. they always needed people, and on and on. So it's different industries. The manufacturers, most of whom are essential, never stopped. So let's talk a little bit about the outline that we gave you. And you'll see we tried to put on the outline, it's number 2, ramping up your business. And so what we tried to do is give you 5 just very general pieces here to look at. There are a million getting back into business plans. They're all good. They're all very detailed and specific. I was chairman of the state chamber, LABI, and we just did one. Jefferson Chamber's done one. Jetco's done one. On and on and on and on and on. And so let's talk a little bit about some generalities and what you do and how you do it. Each industry is different. The facts are going to determine what you end up doing. Everybody's coming up with something different. We've had to brainstorm some things, and some things you just can't do, no matter what, because of your industry, because of where you're located, and on and on. So we'll start with the easy one, which is cleaning and disinfecting. All right, let me talk to you about what is important and what's good. So first of all, obviously you should be doing that. Typically, it's a daily piece. We've recommended deep cleaning at least once a week. Some employers are doing cleaning twice a day, some all day. It depends on what kind of business you have and what you're doing. Let me give you another tip, and that is I would use an outsider to do this. I know you want to use good old Sally who works with you, and you want to have her go out with her little dusting pan. She's one of your people inside, and she works for you, and she does sales during the day or something. And now she's going to come in and dust because she's always done that. Sally does not know how to disinfect. She does not know how to clean. And worse than that, some of these chemicals, OSHA has just started looking at this morning, are harmful to people. So you got to really be careful. Get a pro. There are a lot of pros that do this. And I mean, we have a list of a number of them, and I know the chamber does too, of some of its members who do this. So if I had to suggest something, that'd be it. Keep the hand wipes and sanitizer on stock. Post your CDC, Center for Disease Control guidelines, or World Health Organization, WHO, and make sure people are following those. Social distancing, we've all heard that. Brand new term. Nobody ever used that before. So, you know, the typical distance we've heard is 6 feet. Some say 10 feet. Some of you put up plastic shields to stop that. I've heard it called sneeze guards. That's what the restaurants call it. Wearing of masks. Some people have done that. There's a lot of controversy by some about that. You're not going to get the top of the line N95 mask. Please don't try to buy them. We had a client who got a lot of them, and they got scolded for that because of the fact that they are being used by the medical providers. We did the hospital association, they ended up tying in 5 more hospital associations around the country. And they pleaded to us to tell everybody else we were talking to, please do not buy those. You can make do with regulars. Gloves, frankly, I think they're a waste of time. Remember this, anything that goes on the glove can go on your hand. So you got to wash the gloves too. There are some people who think they're important. I will tell you, just talking about industries, the restaurant industry, I talked to one of our clients who's has a string of restaurants around the country, and I said, what is the purpose of the gloves? He said, Fred, it's not anything but PR. When the customers see us in there, they say, oh, good, you're using gloves. So I would say that is the main piece of it. They're not going to be any safer washing their hands than they will be washing the gloves. That's really been documented. I mean, you know the drill, separating workplaces, being careful about the common areas and the elevators that some of you might have in buildings and all of the lot. Our friend Lee Giorgio, who owns a number of buildings, has taken those sort of protective elements, and his buildings are as safe as they can be, just like all of the other buildings. So potential testing, always get questions about this. We actually did a training seminar on this. The last one we did live for the doctors and the healthcare facilities. They started sucking wind right after that, unfortunately, with the elimination of elective surgery and office visits. But there was a lot of discussion there Also present were some manufacturers too, because they have RNs working for them about taking temperatures and asking questions and all that. Without going into all the specifics about what the EOC and OSHA think about that, just tell you, we have clients that tell me all the time, I don't really care what they say, just tell me what to do. Okay. So basically, taking temperatures the taking of temperatures a little bit more problematic. Some employers are doing it, some aren't. You are making healthcare records. We call it PHI, protected health information. The hospitals and your providers know well what that is. It requires lots of confidentiality. You're not supposed to talk about other people's medical in front of other people. You're supposed to keep it separate in separate files and there's a lot of those. It is better to do this with an RN, LPN, but you'll never do that. You're going to use good old Susie, who's your marketing head, or good old Johnny, who's your head of maintenance, or just somebody in your organization, or you. And that's what you're going to do. So that's fine. There's some ifs, ands, and buts about that. And frankly, as you well know, it's not a perfect system. It's not as accurate as it might be. People walk around with being asymptomatic. They're not going to test with a high degree of temperature. People who ran down the hall are going to test over. The CDC says if you're over 100.4, that's the key. So some people might test over that. So there's some ifs, ands, and buts. I got a call last week. We do a lot of work in every industry, including governments. And so we got a call from one of the governmental entities, and they are going to use it for their big building. They've got a huge building, and they're going to use it. I'm going to test everybody. You want to come in the building? You want to go get a driver's license? Whatever you want, we're going to make you test. And if you're over 100.4, but we're using an RN. They're a big organization. We've got an imaging machine, which they bought, and things that you aren't going to do. Interesting, they were going to use it for one of the judges. There's a lot, obviously, they have a courtroom with lots of judges. And one of the judges, I don't know the man, he called me, he said, Fred, you have to get me exempted. I said, why? He said, because my brother-in-law comes in all the time and I don't want to subject me to this. Okay, we're not going to exempt your brother-in-law or you. We're not going to exempt them from the metal detector, which is also there, if they have a gun. And we're not going to exempt them from that. If we're going to do it, we're going to do it for everybody. We're working remotely. Some of you have people doing that. Some don't. There are a lot of considerations. I'll mention a couple. First, can you do it productively and efficiently? I had 10 jobs coming through school. One was in HR before I went in the military. And I will tell you that was always the idea. Be productive and efficient, whether you're working at home or not. So can they be? Are they salaried exempt? Are they hourly paid? The net major issue also, I mean, aside from keeping track of whether they're being productive and efficient, it's different for different people, is security. If you're letting them use a laptop, is it ours or is it theirs? And there's some pieces that need to be visited. You do not want them using their laptop, which may have a virus in it. And I'm talking about an electronic virus. And let me pick up returning employees to work. Been getting a lot of questions about that around the country as people start returning or ramping up and providing more hours. Some of you did quote unquote furloughs, which is just basically a nice way of saying reducing work hours. Some did official layoffs. For some, we did job elimination. Some of you are going to be doing that again after this 8 weeks PPP runs out. We have a lot of clients we're working on settlement agreements because guess what? We discovered, hey, even in a good time, we've got three people we don't need. We don't know what they were doing during the last 8 weeks. They weren't doing anything because they don't do anything at work. We used to call it in the military, retired in place, RIP. They retired in place. They retired and we really didn't know they retired. They forgot to tell us. They're just showing up. So some of you are going to be doing that. But when you return the employees to work, if you're going to do it, not have them all come in at one spell, you need to be clear about who you're going to bring in, have a system for that so we don't get accused of discrimination, and find out the reason why they can't come if they say they can't come. Is it a legally protected reason? Ryan's going to talk a little bit about something we have done 2 or 3 seminars on. I know Ryan's done a lot on this too. That's the new federal paid sick leave laws, which impact a lot of you for the first time under FMLA because you have less than 50 employees. That is an issue. Some people might use that as a reason. Some may have already used it as a reason, and there are other reasons that they may use. All right, let me flip over to preventive maintenance, and I will stop and turn it over to Ryan. Just a couple of pieces here. First, educate the workforce. You need to have some discussions with people, if you haven't already done that, about what we are doing to maintain this safe workplace. You're not doing everything, but you're doing a lot. Lowering the chance of them contracting the disease, and having supervisors report to you somebody who looks sick, has the symptoms, or somebody who's not doing what you want them to do. If you want them to wear masks, they're not doing it. If you want them to stay away from each other, they're not doing it. And we're going to have a little talk with them to make sure they're doing it. We want to audit our personnel policies. We've redrafted a number of them. I frankly have told clients not to have us redraft the one on paid leaves, because it's going away December 31st, and I don't see any reason to do that right now. I mean, we have some very large clients we've done that for, but frankly, I don't think it's worthwhile for the others, and you can just do it without some sort of policy until we see what happens December 31st or before that. You can have some issues with vacations. They're piling up. What do you do? There's some things we can do about that. And we're going to have some, what I call, fill the hole. For a lot of you, we've drafted your paid leave policies, and fortunately we didn't know this was going to happen, but we knew someday something was going to happen, so we've already managed to tailor it to something bad happening. So it'll work. But the question is, it depends on your culture, do you want to fill the hole? So when you pay somebody partial under the paid sick leave laws that Ryan's going to talk about, do you want to fill that 2/3 of pay hole with 1/3 of what you personally provide under your personal paid leave policy, PTO policy, vacation, sick leave, whatever it is that you have? Everybody's got something different. And then I will tell you, you ought to discuss the potential challenge with somebody who can advise you. You're going to do it under attorney-client privilege, which is a smart move. Better to be safe than sorry. A number of you who are larger are going to have issues. I hope we've gotten to everybody, but we probably haven't. With the plaintiffs already sharpening their knives about the WARN Act, federal plant closing law, which those of you that have 100 or more employees should have provided to employees and still have a chance to do it. If you had layoffs at all, you've got an exemption, but you got to give the warning. We had a very large client who had not given it. We did it. We've managed, I think, to at least avoid some of the problems. The wage and hour lawsuits are particularly prevalent with people who either have been reduced from salaried exempt, hopefully they were actually salaried exempt, to hourly, or those that are working at home, or those who've come in and not signed in and not been paid, things like that. So there are going to be a number of those that happen once this tails down a little bit. So be careful. And now we'll turn it over to Ryan, and he will talk to you about his part of the webinar.
Thank you, Fred. And I want to thank Alex and Todd and the whole chamber staff. You know, Fred touched on this, but I really, along with, the other members of the chamber and serving on the board, very proud to be on that board, and appreciate all the work that you guys have been doing, especially through the pandemic, and allowing me to present today, not only to share some info, but also gave me a good reason to put on a collared shirt. So I appreciate that. It's a tough act to follow with Fred. He's one of the sharpest minds when it comes to all things labor and employment. He and I work very closely on some of the topics I'm going to talk about today, which I really want to cover. Number one, just a general overview of what impact this COVID-19 could have on the healthcare cost and the health insurance environment, and then specifically touch on COVID-19 relief impact on employee benefits, the Families First Coronavirus Response Act, which is the expanded FMLA and emergency paid leave. And then at the very end, if we have time, Fred covered a good bit of this, is just EEOC updates on COVID-19 and how that could interact with the ADA. So I have a lot of alphabet soup of federal agencies and laws and how this will all play out moving forward. But before we jump into that, I do want to say I am not an attorney, so this is not legal advice. Give the full disclosure disclaimer. If you do need legal counsel, call Fred. So with that, if we can go to the next slide, Alex. So a bit of an overview on COVID-19 and the impact it could have on health insurance market. Seen a lot of different studies out there, and the range of cost is pretty broad because, again, we're still very early on in this. As low as $34 billion of direct COVID-related cost, and as high as $556 billion, and that's looking at a 2-year run. So what does that mean for the healthcare market and employer-sponsored plans? Kind of go one of two ways. If we curtail this thing as a nation quickly and get it under control, and there's a vaccine that's rapidly available and it's effective, hopefully we could contain some of that cost, and you'll see health insurance costs rise at a predictable level, like they are now, typically 6 to 8% annually. However, there's a more likely scenario where infections continue to rise, costs continue to escalate, and you'll see a larger uptick in renewal rates for you and your health insurance plans. So be on the lookout for that. And obviously it's a very fluid situation and constantly moving. Next slide, please, Alex. So the COVID-19 relief impact, and this is really focusing on the DOL and their relief notice 2020-01. And there's 3 major areas that this is going to impact. One is special enrollments. The second is COBRA and how that is going to be administered moving forward. And then the third is on the claims piece, claims for benefits, appeals, and review. I'm not going to spend a whole lot of time on that, but just be aware that that is impacted by this notice. So the first thing is defining this relief period. It starts on March 1st and it will continue until 60 days after the announcement of the end of the national emergency. And that's the outbreak period, if you will. So again, very fluid moving target because none of these dates have been firmly decided upon yet, but and it can exceed a year currently as it stands. So how this will impact special enrollment periods. The notice allows for employers to have some flexibility in terms of general special enrollments and how that would impact their tax-free, pre-tax Section 125 status. Again, that's at the employer's discretion. So they can allow employees to make a new election if they previously declined, revoke an existing election, or change retroactively to January 1. That's, again, up to the employer. However, on the special enrollment periods that would normally have a 30-day window to elect, that is changing. So I just want to give a quick example of how this special enrollment will be managed moving forward. So if you have an individual who previously declined to participate in your health plan, and on March 31st, for this example, that individual gave birth and would now like to enroll herself and the child into the plan, but open enrollment doesn't begin for, let's say, November 15th. When can that employee exercise the special enrollment opportunity? So in this example, if we have a national emergency that ended on April 30th, that outbreak period that I talked about previously wouldn't end until June 29th. So this employee would have 30 days following the end of that period to enroll in the coverage. So she would have all the way till July 29th to enroll her and her dependent into the plan, provided the premiums are paid. So again, it's kind of a very detailed example, but you can see how this is going to open up the window for folks to come on board, add dependents, make changes in a way that most of our HR folks and small business owners are not accustomed to administering. So if you have questions on that, obviously reach out to your broker or carrier or attorney to see what is the best course of action on a case-by-case basis. Similarly, as it relates to COBRA, there are some changes as well. So I do want to, again, give you a quick example using the same parameters, right? With the outbreak period ending in April, which again is not the case, but just for the sake of this example, if you have an employee who works in your plan, then sees a reduction in hours and no longer meets the eligibility requirements and becomes COBRA eligible, how long do they have to enroll in COBRA? So if you look at that example, the COBRA election period is 60 days after the end of the outbreak period, which in this case would be June 29th. So this employee would have all the way to August 28th to elect COBRA, even though the event happened on April 1st. So it's, again, a very big moving target. There's also impacts on how the premiums are paid and the grace periods and allowances there. I won't, again, get into too many details on that right now just for the sake of time. But be aware that there's going to be a lot more gray area in terms of how employees can elect and pay for COBRA moving forward, and the grace periods are pretty significant. And again, that's for folks with 20 or more employees. As far as those employers who may have less than 20 and fall into the Louisiana state continuation for this type of benefit, there is no guidance from Louisiana Department of Insurance on any upcoming changes related to state continuation. So as of this morning, we haven't seen anything that would lead us to believe state continuation is changing in terms of how it's administered. All right, next slide, please, Alex. So to the expansion of the FMLA and paid sick leave, I do want to give a quick overview on some of the major elements of this law. So there's two big provisions. One is the emergency paid sick leave, and the second is the emergency FMLA expansion. So a big part, and Fred touched on this as well, is who's impacted. So it's basically every employer with fewer than 500 employees. Those with more than 500 employees are exempt from these provisions. There's also a small business exemption that you would have to apply for. And I can touch on that a little bit more if we have time later. But for a lot of folks on the call, this may be the first time that you're having to interact with any type of FMLA given the size of your group. So there are a few considerations here, and this is a change from traditional FMLA as well, as which employees would be eligible to request this particular leave type. So it's any full-time or part-time employee who's been employed with you for 30 days. That's, again, a big change from traditional FMLA, which has much higher service requirements to be eligible. So looking at which leave is applied when, again, there's two major components. So the first would be an employee who's requesting the emergency paid sick leave, which they fall into two buckets, if you will. One will be if the employee is requesting it on their own behalf because they've been quarantined or asked to self-quarantine by a healthcare provider, or experiencing symptoms and seeking diagnosis. Those folks are going to be eligible for paid sick leave of up to 2 weeks or 80 hours at their regular rate of pay. And there's caps on that of $511 per day or $5,110 in aggregate. So that's one bucket under the emergency paid sick leave. The second, and what you may be experiencing more of at this time, is an employee who's unable to work for reasons due to caring for an individual who's under quarantine or having to care for a child because their school or place of care has been closed due to COVID-19. So again, these folks are also eligible for 2 weeks of paid leave. However, it's at 2/3 their regular rate of pay, up to $200 per day or $2,000 in aggregate. So shifting to the FMLA expansion, in addition to the paid sick leave, under the expanded FMLA, an employee who's unable to work, and that includes telework, because of need to care for a child, because they're current place of care is closed, our school is closed due to COVID-19, is entitled to the paid FMLA equal again to 2/3 of their rate of pay, up to $200 a day or $10,000 in aggregate. So in effect, that type of employee is going to have access to 12 weeks of paid leave at 2/3 their rate of pay, with a effective $12,000 aggregate on that. Now, these paid leaves do have some tax considerations as well. So I would consult with your CPA on how to record that, to make sure you can take advantage of the tax benefit associated with this expanded law. So I do want to touch on how this may interact with other types of leave. So again, these two laws would run concurrently. So if you have, again, that employee who's taking leave to care for a child, first 2 weeks would be under the emergency paid sick leave, and the following 10 under the expanded FMLA. As it relates to traditional FMLA, an employee is entitled to 12 weeks of expanded FMLA. This amount would be reduced by the amount of any traditional FMLA leave that the employee took within their current FMLA year, up to the full 12. So if you have an employee who's already taken their full 12, they're no longer eligible for this expanded FMLA if they've exhausted their FMLA benefit. And then as far as employer leave, Fred touched on this as well. This is important when it comes to referring to your own individual policy and how you set up PTO within your organization. But it is important to note that employers may not require or coerce employees to use another source of paid or unpaid leave before taking the expanded FMLA leave. However, the employers may require, or employees can choose to use any accrued leave available for child care purposes concurrently with the expanded FMLA. So this could be personal time or PTO, but again, consult with your attorney and make sure that your actions reflect the policies that you have in place for paid time off. As far as documentation, obviously important to document requests for leave. Right now, the guidance I'm seeing is retain these records for 4 years, regardless if you grant the leave. And basic information that you'll need when an employee is requesting this type of leave: name, dates, qualifying reason, oral or written statement that the employee is unable to work for that reason. And then there may be additional documents that you can request from that employee to support the particular reason for the request, if that makes sense. And that, again, kind of on a case-by-case basis. Next slide, Alex, please. I know I'm kind of up against the clock here, so I'll be brief on this slide. This is really looking at employers with 15 or more employees and how what they're doing in their return to work efforts may interact with the ADA. You know, Fred touched on this. Normally, you wouldn't be allowed to ask folks to take their temperature before coming in the office, but because this is still defined as a pandemic, there are some flexibilities in what you can ask an employee. Big things, confidentiality of medical records. Make sure you limit who's involved in the collection of any of this info. So if you have people scanning temps, make sure it's as few people as possible administering that, and that you're securing that data or information in a HIPAA compliant fashion. The other thing is just at-risk employees. You wouldn't want to proactively prohibit any folks for returning to work. So you can't say, hey, if you're 60, 65, stay home, that kind of thing. And then if there are requests for reasonable accommodations, as always, make sure you engage in the interactive process, work with your attorney on what would be reasonable. And it may be best to approach that or this entire element along with the phases that the CDC and the government is going to advise us on return to work action. So, and finally, just make sure that, again, you're avoiding unintentional discrimination or disparate impact when it comes to layoffs, rehires, that type of thing, because you want to be conscious of protected classes and their rights as a protective class. And while that may not be your intention to discriminate or anything like that, you just want to make sure that you're aware of it. So with that, I'll turn it back over to Alex, because I think my time is up, and we'll go from there. Thank you all for your time and attention.
Thank you, Ryan and Fred. So now I am going to, as I mentioned before, we can definitely enter your questions into the Zoom group chat, but I'm also going to see if I can just, let's see, gallery view everybody, and I can now see you all. So if your video isn't on, then feel free to enter those questions into the chat. But if your video is on, then you could just kind of raise your hand and I'll unmute you and you can ask your question. Tim.
Good afternoon, everybody. Thanks, Ryan. Thanks, Fred. I appreciate you guys doing this today. My organization is 62 groups that meet around Louisiana and Mississippi face-to-face, or at least they used to. They're all online right now, meeting on Zoom. My question to you is, what is the organization and the leadership team's exposure as these groups start coming to meet face-to-face? What's our liability?
Ryan, you want me to do that?
Yep.
Okay. Good question, Tim. The answer is we're trying to get that resolved right now. I don't know if you've been following it, but both at the federal level and at the state level, there are efforts to have employers have some sort of immunity, or at least a high standard to prove a damage case against an employer by an allegation that the person contracted the disease on their premises. So I think the federal one is going to be held up because they're not going to, I don't think Congress is going to pass anything because that's going to hold it up. But at the state one, I actually wrote the first iteration of that for the state chamber, so pretty familiar with it. And I'm also head of the Civil Justice Reform Committee for the state chamber. So, and we talked a lot about that at Jefferson Chamber and all of that. So it is going to pass. There's been a lot of work done on it. It will pass. In fact, it did pass the Senate committee. It's going to pass the House. It's going to get to the governor. I think he will sign it. It's going to offer some difficulty to those who want to try to prove something like that from the outside. I think they'll have a high bar to get to prove that, and maybe won't attract as many people. But I think to answer your question, though, Tim, I think if we've done what's reasonable and tried to abide by the CDC guidelines, that sure goes a long way towards a defense, and really tough to prove that we've done something that's unreasonable. So I think you're in pretty good shape if you do that.
Awesome.
Help.
Thanks, Fred. Thanks, Ryan. Appreciate you. Thanks,
Sure.
Al.
Of course. Okay. I know we've got a question from Tisha in the chat box. She says, with Louisiana's pregnancy law, if an employee has utilized the 12-week leave under the EFMLA or regular FMLA, would they be entitled to additional time under the pregnancy law? I apologize. I don't have video or audio at this time. Thanks, Tisha.
You and me, Ryan.
I'll let you take the first crack at it because there's a legal undertone to that question. So I'll let you.
Okay. All right. So, you know, a lot of these are so factually determinative that it's really hard to give an answer. But I'll tell you, generally, because it depends on whether or not you've got 50 or more employees, so you're covered by FMLA. Ryan mentioned that. And it also depends on whether the person's what your policy says. I mean, a lot of these we've just written different ways. So bottom line is that the pregnancy discrimination law in Louisiana is supposed, it's a very old law. It runs 4 months. FMLA runs 12 weeks, and we write the policies, we try to make both those depend on each other and run at the same time. So it depends on, like I said, what your policy is and whether or not the person that under the state law, they have to still be disabled in some way. Under the federal law, they just have to be staying home with a newborn. So the policies need to differentiate between that. And I don't know how else to answer that other than that without knowing, all the specifics. Ryan?
No, that was going to be the big key differentiator is the disability component that, so you have to know kind of why or the conditions of the employee and why they're unable to return to work beyond week 12.
Joel, did you have a question? No? Okay. No. Any other questions? Let's see. Do we have anything in the Tisha? Thank you. Let's see. Anybody else have any questions for Fred or Ryan? I guess, Ryan, I know you said on the slide with the ADA, I mean, I know there's just so much information coming out now. Was there anything else that maybe we didn't have time for during the presentation, or any kind of like maybe examples of situations that you think would be most relevant to go over?
I will say, one thing I heard recently, and this was on a JEDCO webinar related to a similar topic, and I'd like to get Fred's thoughts on this as well, is that fear of contracting the virus, COVID-19, is not an eligible claim under the ADA, which I think will be important for employers to be aware of, because you may have certain employees who claim that they can't return to work because they're fearful of contracting it, and how to best handle that situation. So again, not being an attorney, I'm not in a position to render an opinion, but I would like to get Fred's opinion on that, because I think it's something that our employers are going to hear, especially as we ramp up phase 1, phase 2 return to work efforts. So
yeah, I'm going to answer that. I may have not said this when Tisha asked her question. She works for Mark's company, so give Mark our best. He teaches at UNO like the rest of us. Okay, so let me just, I don't think I was clear enough on the back part of your question, which is that yes, you're going to be required to accommodate beyond the 12 weeks or beyond the 4 months even, if the person has a disability under the Americans with Disabilities Act. And then we get into all the specifics about who, what, when, where, and why. But yes, you do. That doesn't really cut it off. We still see policies that say after, Ryan, I know you've experienced this too, after your ADA, after your FMLA ends, family medical leave, 12 weeks, are your pregnancy discrimination, pregnancy accommodation leave ends, we're going to fire you because you didn't return. Don't do that. I'll just say, don't do that. Okay. All right. So question about that. I know somebody could probably, in California, somebody could probably make a case that extreme anxiety and stress and all of that sort of thing is some sort of medical condition that keeps you from coming to work. I mean, the truth is everybody in the whole world has anxiety, stress, and concern about going out in public. I mean, you got to be crazy if you don't. So we all have that. That to me and to most of the agencies, federal and state, is not an acceptable, legally protected reason for not coming to work. We've had that a long time. And I'll give you an example. About the first week back in March, we had I'm trying to remember who it was a retailer or a bank, it must have been a bank, out west, and had a lady, 30 years old, perfect condition, no kids, nothing. Just she called in and she wants to, the drill, she wants to draw unemployment. So just before the excess employment from the feds went in, the extra $600, and she didn't want to come in. I asked her why. She said, I'm stressed, I'm anxious, I'm concerned, yada, yada, all that stuff. She's got her own office, so really not a lot to be concerned about, but some. And they took a strident position because just their culture and the way they work. And they basically said, it's one of those TB. That's a legal word for tough bananas. It's tough bananas. So come in on Monday morning at 8, or you're going to be fired. Now, I don't think that's the best way to handle it. And that was not our recommendation, but we deal with what the client wants to do, and it wasn't illegal, and then okay, we'll adjust around that. So that is not, it's a good question, Ryan, because it's not protected activity. And so when you're bringing people back or they have excuses, the first thing to ask is, why are you not coming to work? Why are you not working the extra hours? That's what you want to ask, and then we go from there.
Thank you. Question from Monica. She says, how are other employers handling employees whom are not disclosing to the employer that they are experiencing symptoms and have sought a diagnosis until they actually receive the actual positive result, which means they've already exposed other employees?
You want to, Ryan, you want to?
Yeah, sure. I mean, every employer is going to handle the situation differently. And Fred kind of touched on some of the inherent challenges of asking, or clearly getting an employee to illustrate that they may have symptoms of COVID-19. And temperature taking is a good example. Not everyone who has it has a fever. You can always ask the employees to submit a written or verbal statement saying, look, I don't display any of the symptoms, fever, shortness of breath, et cetera, et cetera. But there is no, to my knowledge, any clear-cut way of getting or forcing your employees to tell you that they have sought out treatment or think they may potentially have it without asking those kind of questions. Are you displaying any symptoms of COVID-19? If so, stay home. If not, come to work. It's really, best practice there from an HR standpoint, in my opinion, would be to ask the question, record the response, save it confidentially. And then if and when an employee tells you, hey, I've been diagnosed with COVID-19 and I've been at work for X days and in these places, let your other employees know in a very general, broad sense that someone who was physically present at your place of employment has tested positive. Don't use any key identifiers because you don't want to get into a HIPAA issue there, but let them know that has been the case. And that would be my general advice from an HR standpoint.
Yeah, you think you've seen everything, and this COVID-19 situation is raising lots of different issues. But we had one like this about 5 weeks ago in a unionized operation, Teamsters union operation, trucker and warehouse. And our union steward had gone to see a physician to be diagnosed, and he was tested and didn't tell us at all. He came to work and he was slopped over all the machinery, and he couldn't get up, and he couldn't drive the forklift and all kinds of things. And they noticed it and brought him in, and he had infected the entire night shift, by the way. Then none of them got it, thank God, but he did. So we had to let everybody, we basically had everybody go home for 2 weeks, which is what we ended up doing. Now you can do something different in the CDC guidelines, but back then you couldn't. So we brought him in. Of course, he claimed he didn't know, and it wasn't, all that sort of things that people claim. Fortunately for us, we went back to the tape. I had him look at the tape, and he actually had been grazing in the warehouse and drinking and eating product. So we had a different situation. Bottom line is, the only way to really tell, you ask people 2 ways. Brian mentioned one. Number one, you ask everybody, please report if you've got the symptoms. And all of us are walking around with some sort of allergy or something. We have a cough, or we lose our voice or something. So maybe it's not what you think it is, but you never know. And another way, we've had some clients and we've actually developed it for them to have questionnaires. They don't do a temperature. They just, but I mean, if you're not a large employer and you're doing a questionnaire each and every single day, that's pretty tough. I mean, how do you do that? It takes them, 5-10 minutes to fill it out. It's probably may well be compensable time under the wage and hour law. I mean, you really want to do that? And then you put, I swear under oath that this is, and then they come up with some excuses why they didn't tell you. They forgot, something. So really, a discharge for that's probably not the way to go unless you can certainly show intent, some sort of intent, because they're going to use some sort of other reason that's legally protected to come at us. So all you can do is the best you can do. We talked about this for the last 6 weeks. You don't know where people go at night. You just don't. So they're walking down the street and somebody sneezes, they walk through it. They're jogging and other people jogging next to them. We've had people, I've had a million of these. We've had people who give a birthday party for their kids. They had 200 people at the birthday party. You've seen some of these online, on Yahoo. Had a lady who wanted to go to a reunion. They were still going to have it. She's going to get on an airplane and fly to Nashville and be with all her friends. I mean, there's a lot of this sort of thing going on that people just don't seem to care too much, and we have to deal with it from a workplace issue. So those are the ways to, some of the ways to deal with it, and you got to strategize and figure out, what to do in a particular situation.
Thank you, Fred. So I want to thank Monica for that question. And then Missy has a question. Do you advise employers to survey their staff with their ability to return to work? And if so, what other questions would you advise in this survey?
Well, you want to answer, Brian? You want to?
Well, I think, Fred just hit a little bit on it. It's, kind of number one, what is your administrative capacity to appropriately manage and maintain this type of survey process? And then number two, how deep into it do you want to go? So without being too redundant with what Fred just said, I think it's kind of the answer there.
Yeah, that's good. That's good. I mean, I can't tell from the question whether or not, I think we can't tell whether or not we're ready to bring these people back. I think what the question is, why don't we just go survey and see who can come back? I mean, I wouldn't go that direction. I was on the phone over the weekend with somebody, and we're going to start bringing people back, and got to decide, how do you want to bring them back? I mean, is it a particular shift? Is it a particular qualification? Is it a particular job? And then how do you go about this? Just requires some discussion and thought. Which ones do you go with first? Which ones do you go with last? And I think you don't get to that point about whether they can physically return until you ask them to come in after you've developed the list based on some legitimate business reasons as to why you want to go that direction. Then you find out if somebody can or can't come in, and you just determine what to do about them, go on to the next person.
Oops, I was muted. Sorry. Thank you, Missy, for the question. So I think we are just about out of time, but we do have time for one more question. Does anybody have something that wasn't addressed that they're looking for expert advice on? All right. Well, Fred and Ryan, I can't thank you enough for your time today, for sharing these presentations with us and your expert advice. This was our first LiveWell Jefferson webinar, and I think it was great, very educational. I certainly enjoyed it. I hope everybody else did too. And hopefully, if technology's on our side today, this was all recorded. So I will be trying to upload it to our YouTube account, upload it to the LiveWell Jefferson account. And that way, if you want to go back, if you missed something, if you need to rewind, rewatch it, whatever, Ryan and Fred's contact information will be on there as well. So it'll all be online, but can't thank you all enough for joining us today, and have a great.
Thank you for having me.
Thanks.
Thank you.